where a hearing was held last week for the man accused in the 2023 stabbing death of Amber Spradlin. The 38-year-old was found dead last summer in the home of prominent dentist Michael McKinney II. More than a year later, police charged McKinney's son, MK III, with murder and multiple counts of evidence tampering in that case. McKinney Sr. and a family friend, Josh Mullins, were also charged with multiple counts of complicity to tampering with evidence. Now, during the hearing last week, MK's defense tried to argue for a reduced bail. Take a listen.
What the opposing judge is, it's either a 10% of the $5 million bond posted, cash or property, and we would post that and be obligated to the balance of the $4.5 million that is the court's current bond. The issue with that, Judge, is that's what the law, the court's well aware, that's what the law really requires in this case. It is, does the defendant have any record? He has none. Is there any risk of non-appearance? As we state in our motion, Judge, it's been known for a year that he might be charged with this offense. There's, you know, as the detective states repeatedly in various interviews, the rumor mill of this had been more than he could actually deal with. He was working with that more than he was the investigation. So he has known this was coming, and yet he was in his apartment when they came to arrest him. 3 days after this, Mr. Jacobs was representing him at that time, tells him to bring his truck for KSP to process. He does that, voluntarily brings his truck in and lets them process it. He also comes in and gives a DNA sample, voluntarily. They had a warrant for it, but he drove to the post and met him. So in regard to any allegations of risk of flight, it's completely rebutted by not only his conduct, but the risk assessment. And the Commonwealth doesn't address any of those in their response. And Judge, this is obviously a high profile and serious case. Right? There's a lot of emotion involved. And cases like this, that are this serious and this emotionally wrought, there's only one thing to do, and that's follow the law. And the law in this case, Judge, basically dictates he should be released on bond, especially when we're talking about it being another year, possibly, until we get evidence back, maybe more. The detective in our discussion force says it could be a year, it could be more. And so we've got a defendant here who's presumed innocent, who may be sitting in jail while we wait. Oh, it's already been a year to get test results back, another year to get information back. Who his pretrial risk assessment makes it clear and the allegation that he's a danger to the community. He's 25 years old and has a speeding ticket for 5 miles per hour over. That's it. The Commonwealth talks in their response that he pulled a knife at a party. The detective interviewed that individual. He could not name another person that could confirm that information. Not a single one. He also did not provide that information till 14 days after this occurs. And after he's communicating with paramours of the victim's family who contact the police on his behalf and tell them he has information. So this whole pulling a knife, there's not a single other person who supports that story. He says there's 25 to 30 people there. According to the detective, not a single other person could confirm this. The other thing, Judge, is they say in their motion that Mr. McKinney has dark thoughts and hears voices. They repeatedly talk about that. That information came solely from one source, Roy Kidd. And he told the detective on June 28th, 10 days after this happened, that MK has, here's dark voices, has dark thoughts, hearing voices. What's important about that, Judge, is the day after this murder, on June 19th, when this same witness was interviewed, he never mentions anything about any of this stuff. Not one single thing that they refer to about hearing voices and all these things that Mr. Kidd tells them, does he ever tell the police the day after this murder. 13 days, 12 days later, he all of a sudden comes up with this stuff. And that's their evidence that he's somehow a danger. There is literally, and the court, we can't litigate the case here, evidentiary-wise, but there's a couple things we do need to address, Judge, regarding danger. One of the other issues that the Commonwealth points out in their response are the scratches on Mr. McKinney's arm. And they say that those are defensive wounds that he got from Amber Spradlin. The Detective Wireman's own investigation, he interviewed 2 people who stated that those scratches were there as far back as May 29th. One of the witnesses, who the Commonwealth repeatedly relies on in their response, Roy Kidd, told the detective he had those scratches on his arm the night before the murder. Now, I don't know that Mr. Kidd is a reliable witness, but if they're going to choose to believe him in certain things, they can't ignore the fact that he said he saw the scratches on his arms the night they're out drinking before this murder ever happened. That's their investigation. And again, Your Honor, the law makes it clear that an individual situated such as Mr. McKinney, with no record, no risk of flight, shall be released. And again, we are proposing a substantial bond with restrictive conditions. And one of the key factors, Judge, is as long as we may have to wait to get evidence back, if he's sitting in jail that entire time, that's a miscarriage of justice, because it's not his responsibility to do this testing. And it may, as we discussed, it may put us in a position that we have to ask for a speedy trial, which puts the court, puts everybody in a very difficult situation of having to go to trial without certain evidence, some of which could be exculpatory. But that could be a risk we have to take, Your Honor, if we're having to wait at least a year and possibly more to get back evidence. And so for that reason, Judge, based on those arguments, the rest of the arguments that are contained in our motion, every single factor, Your Honor, would indicate that the $500,000 cash or $1 million property bond surety out of the $5 million, along with the remainder of the conditions that the court said, surrender passport, be on home detention. And Your Honor, I understand it could be a concern that a co-defendant might be living with a co-defendant. We've made arrangements for him to be on home detention somewhere else, so he would not be residing with an actual co-defendant in the case. And so, but the other conditions that the court included in his initial bond, all of those would continue to apply. Thank you, Your Honor.
All right, so that's the defense's argument. We do need to take a break. When we come back, we're going to hear what the prosecutor has to say about why MK McKinney should not be given a reduced bond. Keep it here on your front row seat to justice.
And long.
Welcome back to Court TV Live. I'm Michael Ayala. We're bringing you more of the bond hearing from Michael McKinney III out of Preston, Kentucky. The defendant is accused of murdering 38-year-old Amber Spradlin in June of last year. His father and a family friend are accused of complicity of tampering with evidence. Now, at the hearing held last week, prosecutors argued against McKinney, his third's getting bail, saying he is unstable and dangerous. Take a listen.
Talked a little bit, and you can see in our response, Your Honor, that there's been talk about the scratches and the injuries. And one thing, of course, that wasn't mentioned was the DNA report that Your Honors had an opportunity to review that does directly link one of the McKinneys, or both, to the murder. And also as to, and I'm not going to go through all the other things, I don't see the point in rehashing what you've already read, Your Honor, in terms of all the other incriminating evidence that was disclosed in the Commonwealth's response. But our concern beyond that, getting away from arguing the case and the strength of the case, is we think that there is ample evidence to demonstrate that he is unstable and dangerous. And that would include the lengthy statement in the conversation, which again was a friendly conversation with Roy Kidd at Seasons Inn that night, where, as the court read, defendant MK had told Roy that he hears voices telling him to kill himself, mentioned that his grandmother had killed herself and he was afraid he would end up like her, that he told him he heard dark voices that told him to do bad things and put ideas into his head, and sometimes the voices were taking control of him. As to corroborating that, the fact of that conversation occurring, Roy Kidd didn't volunteer this, but was found on his phone that he had actually had a text conversation with his daughter around 4 a.m. contemporaneously with the conversation with MK, where he expressed concern about MK and even said in one text message that it referred to MK that he's suicidal. So I think that goes a long way to corroborating Roy's statement. You can say, you can try to discredit the guy that, was a friend of the family that didn't really want to be dragged into it, that talked about seeing MK pull a knife on 20-some people in the basement of my home and threaten to kill them all. But, he wasn't out to get anybody. In fact, he was reluctant and didn't want to be involved, but he really wanted to solve because he told the truth. And they would also point, as far as the danger, Your Honors, the history of mental instability. It's all outlined in the response we filed, Your Honor, but he has a pretty thick stack of mental health records. And I referred to some of what was in that, and I don't want to get into too much of it, but in addition to the suicidal ideations and attempts at self-harm, but one of the things that stood out to us was his own statements about his inability to control his anger. That he had instances where he was triggered and couldn't control himself, which is consistent with what we believe occurred here. So, with all that being said, the Commonwealth, obviously, we're objecting to a bond reduction. I understand all of the concerns raised by the defense and speedy trial, all those things. But just on behalf of the Commonwealth, that would be our position, and we trust the court to make the appropriate decision based on the law and the evidence shown.
All right, let's bring back in our guest, still with us, domestic violence expert, former law enforcement officer, Claudia King. Claudia, what do you make of the arguments? At the end of the day, the judge is going to consider, risk of flight, also risk to the community. Sounds like the state has some pretty good evidence that this guy might be a problem if he's left out on the street.
That is what I really focused in on, especially when listening to the prosecution speak, because it doesn't sound like he is a big flight risk. However, as you said, the other piece of bond is a threat or danger to the community. And it sounds like he may have had another instance of threatening with a knife. It does sound like he has an extensive mental health history, in addition to what he allegedly told this friend of his that was reported to the police. And it sounds like in addition to needing mental health evaluation, that it might just not be the right time for him to be out, because we have to worry about the safety of the entire community. This crime was extremely heinous, and I think he is exactly where he needs to be.
Yeah, it certainly sounds that way. One of the interesting things that I took away from the state's argument was, he's talking about hearing voices that are telling him to do bad things. He's got suicidal ideations. I mean, that sounds like the groundwork for the defense to maybe come up with some sort of, mental impairment defense.
I thought the exact same thing. I hope they were taking good notes, because it sounded like the prosecutor was laying out the potential for a defense for them, some type of insanity defense. So if they're not already looking at evaluations for him to determine if this is a possibility, it's definitely the direction that they need to start looking at pretty quickly.
Yeah, I would agree 100%. Now, the guy that they're relying on for a lot of their information, this Roy Kidd guy, you heard the defense attorney mention it. He was one of 3 people in the house. There's this Joshua Mullins who's been charged. We know that the father has been charged, again, with conspiring or complicity in terms of tampering with evidence, but Roy Kidd hasn't been charged. So that's something I think. Now, when you talk about flight risk, one of the things they look at, too, is the strength of the case. So what they're saying is, look, if you're basing this all on this guy who clearly was in the house at the time, has his own issues, and this is what you're basing it on, I think they're making a strong argument, this idea that, hey, maybe the case against him isn't so good.
I think one of the biggest things that has strengthened the case at this point is the DNA, because some of those swabs have come back already, and it does indicate either the son and or the father's DNA was under the victim's fingernails. So I think that definitely is a lot stronger than this other witness's testimony, who, as you said, he has to worry about himself. He's got his own agenda going on right now. So I think they're definitely going to have to bring more to the story here. And it makes me wonder, what else has Mr. Kidd said that we don't know about? What evidence has he brought forth? Is there some type of deal that he has struck that we're not aware of? Why is he the only one that isn't in jail or hasn't been in jail for this crime?
Yeah, all those questions, exactly the questions I had. He also apparently took one of the lie detector test. And in this lie detector test, they were asking for it. The defense wanted it to deal with it. The state said at some point that he had passed it. But again, the defense wants it. We know that's not admissible in court. So why would the defense want it in your mind? What could they use it for at this point in the process?
Even though it's not admissible in court, I think they might want to look at the specific questions that were asked and which specific questions maybe he passed, maybe were a little iffy, and if any questions indicated deception. There's a lot of different ways that those polygraphs can be scored. And so they might want to look at that, because sometimes it's the questions are asked 3 times and basically 2 out of 3 wins. So if you show on a question deceptive once, but not deceptive twice, then the twice wins out. So they may just want to look at specifically the questions that were asked and his actual score of each of those questions.
Yeah, because it sounds like they're probably lining up a couple of different defenses. You could go the mental health way, but you also could say, this other guy did it. Maybe point the key, the finger at him if he's made some sort of deal. The other thing that works against the defense here too is you heard that there were scratches on the forearm of the defendant, although the defense seemed to suggest that there was testimony of people who had seen these scratches prior to the murder. So there's something there that they would have to deal with as well, correct?
Absolutely, and I think you're right. The some other dude did it defense is definitely going to be in play with the other people that were present. The scratches, I think, are kind of iffy, because yes, there may have been scratches there ahead of time, but were all the scratches there? You know what I'm saying? Maybe there was a couple scratches there, but the fact that one of these defendants has the DNA under her nails, that says something right there.
Yeah, the buck pretty much stops right there, I think, when you're talking about releasing this guy. But we'll find out. Stand by, Claudia. We're going to take a break. Coming up next, the defense attorney challenges the prosecution's claim that McKinney is dangerous and unstable. But the state doesn't hold back when reiterating its argument. You'll hear that next. So keep it here on Court TV. Let's turn back now to Kentucky, where a hearing was held last week for the man accused in the 2023 stabbing death of Amber Spradlin. Now, during the hearing last week, MK's defense tried to argue for reduced bail. The defense is now challenging claims by the state that McKinney is unstable and dangerous to the community.
You said, did you want to put on some summary evidence?
Judge, I'd call Detective Wyman if we could.
I don't think that's appropriate, Your Honor, that unless we're talking, I mean, what he's wanting to do sounds to me like is to go and basically go through the case and have a chance to do a cross-examination of the witness side.
No.
The burden is on the Commonwealth in this instance to prove the dangerousness or any other factor that might be considered by the court. And that would be our prerogative if we want to call our own witnesses to prove that we can, but I don't think it's appropriate to, for the defense and the bond game to just start calling all the witnesses and have a mini trial.
Well, I don't want to do that.
We're not having a mini trial, Judge, but I do want to ask him about the investigation regarding his dangerousness, the Mr. McKinney reporting to him voluntarily to have his blood swabbed and providing his truck,
All of those.
where he got the information about dangerousness and hearing voices and all the stuff that they've referred to, it came from him. I want to be able to ask him about it.
It came from the police report that's laid out. They have the statement from Roy Kidd where he says all of this. There's absolutely nothing that Detective Wyman can testify to that they don't already know. They just want to try to go and fish around and ask about some other things and see what will help along the case, which has no relevance to a bond hearing.
Because you just provided the court with Mr. Kidd's statement.
Sure. And I've provided it already, Judge. But
Let me go ahead.
the issue that I do want to point is, I'm not fishing around. It's stuff that he already knows. And it's Mr. Kidd claims about these dark voices that make him a risk. I want to ask him, did he hear that from a single other person in the investigation? He didn't. I want to ask him, did Mr. Kidd say that to you the day after the murder? He didn't. It's only concocted 11 days later. Did you find any medical
Kidd
records?
was not interviewed the day after the murder.
The 19th, he was interviewed.
Interviewed in a recorded interview?
Yes.
You're not recorded interview in that case.
I'll provide it to you. That was provided to us, it was up. So, Judge, that's what I want to point out, is that,
Yeah, he was interviewed at Post on the 28th, I believe.
no, yeah, there's two. Interview with.
As to the transcript, Your Honor, well, everything he said, he's already given the answer to, obviously. If we had someone else who gave a statement about the defendant's mental instability, we would provide that, and we'll in the future we get it. But one thing I would point out is in the defense motions that have been filed, particularly about, I think on the polygraph one, the defense provided a 60-page transcript of an interview with Roy Kidd, but they didn't provide a transcript of the interview where he talks about all this stuff about MK basically being, cuckoo for Cocoa Puffs. I mean, they left out what he's saying he wants to know about. They have that transcript. He didn't provide it to you. We can provide a transcript or the actual recording if you would like to hear it.
I don't want to hear the actual recording.
Ma'am.
I'll take it.
May I throw this, Your Honor?
Yes.
Judge, I'm showing you the UOR report of Detective Wyman that shows the interview conducted with Roy Kidd on June 19th in his own report.
Gunner, I guess my question is if you've got the interview transcripts, they've told you what he said. We can give you the other transcript of what he said. What is Detective Wyman supposed to add to that?
Okay.
Just read what he said?
Judge, I do want to follow up on one thing.
Okay.
Is the evidence that one of the statements counsel just made is of Roy Kidd's statement that he's cuckoo for Cocoa Puffs. We're using that as evidence in a murder case to hold someone on a $5 million bond. That's the argument they're making. I mean, are we serious here, Your Honor?
You got anything else?
No, Your Honor.
Okay. I'm gonna take this under advisement. I'll get you ruling out. I'll get you a ruling out probably tomorrow, maybe.
Thank you, Lonnie.
You have to wait a year for all these?
I don't know. All of what we're basing it on is we're trying to base it on what we've had up to this point. And to give you a chronology on it, the summer of 23, murder occurs. First round of evidence is submitted to the lab, which again, they severely limit our ability to get stuff tested because they won't take it all. They say they want 10 items is their normal rule, but he was able to provide about 30. We begged and pleaded with the lab director. We put all the pressure we could on them. They got us a serology report a few months later in the fall. Then they got us the initial DNA testing, first submission. I don't have the report, but it was like late spring. And then that led to the necessity of doing a YSDR test on fingernail clippings that the court has the report there. And if you look at that report, it wasn't until like June 28th or something. So to have the first round of DNA, even with them rushing it before we got everything we needed, was a year. And then one item, the knife found in the couch that the Commonwealth has alleged was planted, they had, without our request, Central Lab had taken that item and sent it to the Northern Lab for testing, and also because they had to do prints with Avis. And they just sent us it's in the stuff you've got, I think, Steve, that report, the initial, what I call the serology report, not too long ago, which is over a year. So that would be kind of a comparison of what they do when they're not rushing. And of course, the court's aware, I'm sure, that the problem with the lab is not a matter of competence or technology. They have everything that anybody else has, including the FBI. It's simply that they are tasked with doing all forensic testing, DNA, blood alcohol, drugs, trace evidence, hair, fingerprints, electronic crimes, phones, computers, for every police agency in the state of Kentucky. Every sheriff's office, every tiny little PD office in the middle of nowhere, they submit that. So there's been stories on the Herald Leader about it. They're about 70% staff. They're doing as fast as they can. When I've had discussions with them, and I try not to be harsh with them because I know they're doing the best they can, that the common refrain I get is everybody in the state that's got a big murder case thinks theirs is the most important case too. I understand that. And I know Mr. Romans understands it because we've talked about it. It's not a matter of, anything we can do. We're trying, but I think it could very easily be next summer before we could have even the majority of it tested. And of course, we got to remember too, these are items that very well could be exculpatory.
There are several moving parts in regard to how the case proceeds based on if the defendants are in custody, not in custody, those type of things. And so I don't, and obviously if we could file for a speedy trial prior to the status conference if we needed to, but I don't object to a February date. And if we're going to get discovered within 30 days, we'll be able to process that. If at that time we think we need to go ahead and move for a speedy trial, we can do that prior to that February date, but I don't have an objection to the February.
And one thing I could do too is if we had that date and these other submissions made, is it give me an opportunity maybe to reach out to, is Dave the lab director? I call him the director of the lab, who is the guy who, even though it seems slow, got us this stuff within 6, 8, 9 months, which is fast for them. He's assured me over and over that they have a high priority bin, he calls it, and he says your case is in the high priority bin, but we're not the only case in the high priority bin. There are other people out there, other people incarcerated, etc. But I do think if we had a better handle on exactly what was left and everything, we could go to him and just say, you know, we need some kind of realistic timeline. And it's hard to get that from them sometimes, but they've been pretty good about it. They're usually a little behind, but some things they've told us they actually got it when they said. And then the other thing I had mentioned to defense counsel is because the discovery in this case is so voluminous and there's so many things still outstanding, is maybe later this fall or first of the year or something, we could all get together with the detective and kind of have a discovery conference. I usually don't have to do that, but just one where, I mean, we got so much stuff, we may miss something, you know, to go through and itemize and make sure everybody's got everything, and that might give us a better idea of what the time frame would be. You all agree with that?
I agree. I don't object to that, Judge. Obviously, I think, of course, there's a lot of moving parts regarding it. Judge, I do want to say one other thing about the delay. I'm not alleging that that's the Commonwealth's fault or Detective Lyman's fault. It does happen in a lot of cases, but I know it is not the defendant's fault. And delay in testing and production of evidence should not prejudice a defendant.
All right, the judge would ultimately deny McKinney's request for a bond reduction, citing the fact that the case was very strong against him. His bond was set for $5 million at the time of his arrest, and it will stay that way for the time being.